If you have served in the United States Armed Forces before, thank you for your service. You do remember the date that you were released from your military duty. What was that date called? That was called your discharge date. In this video, we're going to look at ways an executor or an administrator can be discharged from their duties and responsibilities. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. Probate is the legal process of settling a deceased person's estate. Probate is also the process by which heirs and beneficiaries can claim their inheritance. In the state of California, a personal representative must complete all of their duties and responsibilities before they can be discharged from the liability of a probate administration. A California executor or administrator can be discharged from an estate in a few different ways. An executor or an administrator can be discharged once he or she has complied with all of the final distribution orders or filed or excused all receipts of distributees, those persons that are scheduled to receive assets from the estate. In order to finalize the process, the executor or administrator needs to file an ex parte petition, which basically means there is no formal court hearing necessary to close the case. The California Probate Code requires a personal representative to file a final petition and distribution or report the status of the probate administration within 1 year of receiving letters of administration. Another way an executor or an administrator can be discharged from their duties as the personal representative would be if the estate had no property to transfer. If there is no property to transfer, the personal representative can file a petition for discharge. All of the facts need to have been placed in the petition, and all interested parties would have to have been given notice. If the judge agrees with the petition, they'll sign the petition discharging the personal representative. Nevertheless, if the decedent had a considerable amount of debt, the personal representative may want to open a probate for the purpose of setting a deadline for creditors to file their claims or to deal with community property issues with a spouse. Another way the executor or the administrator may discharge a probate estate would be an informal probate. An informal probate is basically closing an estate without a judge. The personal representative has 3 years from the date of the decedent's death to apply for an informal probate. An informal probate involves less paperwork, less money, less court oversight. This may be a good option when there are no disputes in the probate estate for the court to resolve. A personal representative can be discharged from the estate within 1 year of filing what's called a probate closing statement. Question of the day: have you ever administered a probate estate before? If so, how were you discharged? Let us know in the comments below. Once the executor or the administrator has been formally discharged from their duty and responsibilities as the personal representative, they should contact the Franchise Tax Board and the IRS to let them know that they are no longer in charge of that probate estate. If you've gotten value from this video, be sure to like, share, and subscribe. I'm Daryl Williams. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need an estate planning attorney or a probate attorney here in the Southern California area, feel free to contact me for a referral.